Okay, and now we're linked with IP. So hello everyone, my name is Loreto Reguera. I have just recently joined IIPLA Technologies. I have been working before for a big American company, Intel, and now what I would like to share with you is kind of the vision from someone who has been in the IP, what I call the IP game, supporting business from long time, from the perspective of a company that is very much IP savvy. In all areas of IP, going from that to a company that works with technology, is busy with innovation, but their approach to IP is completely different. So it's kind of trying to understand the game, and what can you get from, and looking at the return on investment on using IP. So IIPLA Technologies, it's an international company that provides engineering services to big companies or small companies that just need ad hoc technical support. So basically there is a staff of 13,000 engineers worldwide. In many areas, mostly on automotive, aeronautics, also pharmaceuticals, oil and gas, so all areas of technology, heavy technology oriented sectors that need support on engineering. So the company is just providing that expertise. But by definition, when we work with clients, whether they don't even understand the IP that will be part of the service that we provide, or if they do understand, they just want to get all the IP that eventually will be generated. So that's what I would like to share with you today, is kind of that contrast that I'm facing from a company that really is used to deal with IP, from a company that is that use that every day, but is just needing to adjust and finding the way to value and monetize it.
Well, thank you. So you have 13,000 engineers who, do engineering every day almost, and so they must be generating a lot of creations, which are meant to be protected by intellectual property. So I guess my interest is from a legal professional supporting that organization. What kind of IP rights do you have in mind when thinking about the work that these engineers do? And then, as they interact with customers, I think you said they are going to generate a lot of IP. So how do you distinguish this IP generation interacting with one customers from the IP that you're going to reuse from prior engagements or even your own maybe internal activities? So how can you give us some perspective on these two aspects?
Yeah, absolutely. So there is, we have some technology, the proprietary technology that we develop internally with the aim to offer that to our clients. Basically, for example, we have created Link and Go, that is a car that is automatic, and it's fully connected. So we offer that like a prototype to what could be, what kind of technology can we develop, and that specific prototype and model, we have been able to patent technologies based on that. So we have a whole IIPLA research facility where we develop our own technology with the aim to offer that to our clients. But that's not today our core business. Our core business is to offer the support from engineers, and that is really case by case. So depending of the project that we're helping, sometimes we get an assignment to develop a specific full technology, and that part of that would be the review of the IP that is generated. And sometimes we just offer support on a time and materials basis, kind of depending on how the customer develop on their own, because they don't even know at the beginning what they will need. So it's very complex because it's not a single model, and it's difficult for us to have even a business strategy on how to use our IP. So it really depends of project by project.
Thank you. And what kind of, so I guess when you're interacting with the customer, you sign a contract, you sign an agreement at some point during the deal. And in this agreement, they organize some transfer of rights from your company to the customer. And also, in general, there are warranties, representations, and other good stuff that you have in the contract. Can you give us how you think about this from a supplier perspective with these engineers? What are the common requests that you see from your customers, and how do you handle them?
So I would identify two different kind of situations, and again, going to that differentiation between companies used to deal with IP and not used to deal with IP. So you will have some contracts where the customer already we mostly use the contract from the client because we just that's normally the model. So some clients, they understand what is even the background IP that you will keep and what is that any kind of IP that could be generated. They even establish a license already, so they ask you to give them a license on your background IP that they may need to use to utilize your services. So it's very sophisticated in the sense of that they even give you a license, or that what I ask always, a license on whatever we are creating for them. I can give them the ownership, but then they will give us a license to eventually utilize with other customers. So that can go from very, very sophisticated clauses, where even if it's not clear the outcome of a project, everything is identified in terms of background and foreground and so forth. From there to whether nothing at all, or whether very broad clauses saying that, well, all IP will be owned by the client with no differentiation on what is background IP or anything. And in those cases, obviously, it's then difficult to explain to the other party, well, depending on the kind of services that we're doing, it's likely that something will be generated or not, because if the other party keeps saying you whatever is generated is mine, then it's just not a question of a business discussion. It's a question of IP law education that gets much more difficult when the other party is not used to deal with this kind of clauses.
Thank you. In my experience, when you have a contract with terms that are horrible from a legal perspective, then you just go back to your client, to the business, and you tell them, hey, that language is horrible, we shouldn't accept them, but that's really your decision. And there is always a discussion to have on when is the business ready to walk away from a deal. How do you have that conversation with your client on when they should walk away or not? Or what is there? Is it that you have the level of sophistication or understanding internally such that there is really no such discussion?
Well, that's probably the first step on all that discussion. So first is kind of make your own company understand what is at risk. Because again, if they are not used to monetize the IP that they create, for them the value of the deal is just what they are having for that specific customer, and that is a business decision. And it's very difficult to kind of make them understand all the implications of a bad IP clause, or the implications of accepting like indemnification for infringement of third parties' IP. Because if they have not had that experience or a kind of a litigation in the past, again, if those are not companies, whether the client or whether my own company, we have not been part of that or litigation or case of infringement. So it's difficult to, as a lawyer, to explain all the risks that are involved and what is at stake.
Okay, so do you think how do you still have to have this conversation though? You just, you can't make recommendations completely independent of business expectations, or how do you, what framework do you use to have that conversation with the business? Would a risk management framework be helpful? And if yes, then how do you approach it? Do you just list the risks? Do you quantify them? How do you, what's the right way to approach that conversation?
Well, I assume there are different ways. What I try to do is be as pragmatic as possible. So all of you that work for in-house or with companies, you understand that, well, it's no mean to talk about the law. It's not even mean to talk about infringement of IP and eventual litigation. So what I try to put the focus is on first risk in terms of quantification of insurance that we may need to take to deal with the risk. Also in terms of finance implications. So if there is a huge risk, then you will need to make a reserve, and you could not recognize the revenue upfront of the deal. And also in terms of reputation. So I keep saying, well, a fine or a penalty for infringement, you can afford that. My company is big enough to be able to afford, fines, because there are other suppliers that are so small that they don't even care, because they know if they have an infringement or a litigation, they will directly go out of business, so they don't care, they accept whatever. So my company is big enough to be concerned by that, but what I try to say is the reputational risk. So we are very much into innovation, into technology. We are proud of what we do in the sector. We don't want to be perceived as a company not being not respecting our engagement, not being really specific and sophisticated on our engagement, including all kind of compliance and also IP compliance. So I try to focus on the reputational risk and also how the eventual risk will affect our insurance fees and our revenue recognition.
Well, so cost of insurance, impact on revenue recognition, reputational risks. These make sense from a business perspective, but it's not something you learn in IP law. So how do you, what kind of practitioners where do you get your help basically to quantify those and to give a picture which is informed really on this to your client? Who do you use? Do you go to your IP firm? Do you go to law firms? Do you go to accounting firms? Where do you get the support from? It's
basically the support from finance. So again, the IP law is not into the equation at that level of discussion. It's the help from finance, for internal finance, the department, also all the risk department internally audit. That they can help quantifying the risk or even considering the revenue that we have for a specific deal. If we consider the limitation of liability that we have on that, and then making a kind of a calculation of what would be the revenue that we could take in which time. So it's all about finance in my case. The more than you get into the law in the sense of, well, that's protected by law or not, or register into that, again, the company look at that like a cost. The more than you want to protect, well, if you are, of course, talking about a trademark and you register, but the company is always saying, well, why will need to protect us in advance? We will just deal with whatever things happen later on. And then it's only the support from finance that can help you there, because it's not explaining, well, that's in the law. That would convince any CEO.
Okay, so it makes good sense. I think as in-house counsels, we realize that we have to team with people across the enterprise, very often in support function like finance and others. How do you, or let me rephrase, what kind of IEP issues then do you consider really from your own perspective as a legal person, and do you bring to the table in this discussion, this risk analysis discussions? Can you give us a few examples? I think you mentioned when we were speaking together indemnification issues to the client with a limitation of liability that you just said. The ability to reuse your own technology. There may be others. Can you give us some color on this type of issues?
So something that I try to explain to our engineers is that even if you don't think that you have an IP that is valuable enough to protect yourself, and you say, well, I want to have that deal with that client and they are asking me to give them whatever, I will sign and that's it, because at the end of the day, I'm not even creating much, I'm not creating a patent. Okay, so I will sign whatever. Even if you do that, the risk of signing no matter what is that you can, without even realizing, accepting those kinds of indemnifications and limitations to your later work, in the sense that if that your client could use, for example, your methodology to apply internally or not, but prevent you from using that technology with somebody else. And if you are not even conscious that you have committed to them and not to use that with anybody else, you may be using with other clients or not, but it could give the impression that you are using the same methodology with somebody else. They could come back to you and ask you for royalties for using that methodology, or issue an injunction for you not to do that with if there is their competitor, for example. So again, it's not only about protecting you or protecting your IP if you want to monetize it, is to allow you to be able to stay in business, because you never know if the other company is much sophisticated than you and are really going to ask you to pay them for infringement of whatever they do, blaming that it's your fault, or just simply ask you for paying royalties for whatever you want to keep doing, even if you never thought that it was something innovative that could be qualified as a methodology that could be somehow, or a design that could be somehow protected. So the point is that the moment that you enter into the game, you are exposed to a lot of different risks that you only can deal with if you know the game enough to protect yourself. So entering into that, and that goes for all kind of companies, big and small, that they don't have a clear strategy on IP, because they may decide to go for basically protection, but then depending on the evolution of the sector of the business, they may face attacks from patent trolls, or you name it, or different kind of piracy, depending on the IP. So if you don't have a clear long-term IP strategy, it's very difficult to even take decisions day to day on how to put IP clauses in a contract.
And what about suppliers? How do you? I would imagine that even though you're a very large company with 13,000 employees, I would imagine that from time to time you would also rely on suppliers and reuse assets, that they would supply. Or how do you deal with that aspect?
Yeah, that's also tricky. It's like I said before, what you see is that small companies they accept whatever, because again, you could say they are not sophisticated enough on how it works, so they don't even understand what they're getting into, or not necessarily, because again, at the end of the day, a small company who accepts a non-capped limitation of liability, by all means, that would not be enforceable, because if they accept to pay all the risk, well, they just will pay it to the limit of their social capital, and that's it. There will not be possibility to enforce them, or to oblige them to pay more than that. They will be out of business. So for them, it's kind of easy to accept, because they have their own limits. And then our suppliers, it's tricky to find that balance between saying, okay, we have all those obligations and we pass those obligations to you, but being reasonable and understanding that it's only till a certain extent that we can pass the obligations to them. So at the end of the day, the obligation is ours to be comfortable with what we are accepting, because most of the time we cannot rely on our suppliers to cover whatever they will be needed. It depends, because of course if they are just providing some tools or some technology that we include, then we will ask full protection from them. But if they are just kind of supplying services to us as part of a full package, then we need to be comfortable with our terms directly.
So I'm not sure I follow. So you have a contract with a client, which has a certain level of requirements and obligations for you. And then you may have a different framework, a different set of contractual provisions with a supplier. How do you manage the gap? Would you just take on the risk of such a gap, or what is your approach there?
Basically, it depends of the kind of supplier. Again, there are suppliers that we use that are also big companies, and then try to pass all the risk directly to them, because also they are used to work with those big customers that we have, that they impose conditions that are more difficult to negotiate. Sometimes we just need to really go back to our clients if we need to use a supplier, trying to really be comfortable with the risk, because we know we cannot pass that, even if contractually you pass that to the supplier, we just need to be realistic on when you can get from your supplier. So it really depends.
Right, so do you do that deal by deal, or I would imagine that when you establish relationship with a supplier, you have kind of an assessment, an audit of their own practices. Let's imagine that you're facing with export control issues to some countries. Then there are certain aspects, if you use certain supplier who deal with that particular country which is under a restriction. Yeah. It's something you don't want to find out at the time of the deal. So how do what type of issues do you assess maybe at the beginning of a relationship, and what type of issues do you assess deal by deal?
So, for example, the aeronautics industry is very, very regulated. Everything is under some kind of international standard regulation applicable to that. So most of the time, all companies in that sector, they have to have some kind of certification. So by definition, ourselves, our suppliers, if you don't have those kind of certifications, then you are not in the business. So of course there is a whole process of due diligence that is done before, but then even in those areas, or in areas that there are not such a strong regulation, it also depends on the country, because in some countries we are used to do business there, and the level of the suppliers, we know that the professionality, or this is easy to kind of have the reputation, but in other countries it's very difficult to find counterparts at the level of quality that you're looking for. So again, it's a whole due diligence process that we do at front. But you see, in those kind of things, of course, export control is one of them, but by definition, you will not check the IP sophistication that those suppliers have, or the way that they deal with their IP. It's kind of that's not in the first thing that an auditor or an agent doing the due diligence will think about. Which is, so depending on the kind of deal that you are providing, that would be probably what you will need. But that's something that then the lawyers will need to kind of force and say, okay, and how are those guys dealing with that? If in case, for example, that you get a company like in Israel, there are a lot of software companies. So it's not just looking at the technology or looking at the solvency of the company itself, it's that how do they protect their IP? Because if I include that into my tools, then it could have a lot of implications.
Okay, so it sounds like you have to work with maybe other legal professionals or auditors who may not be completely aware of IP issues, and even your own, the employees of your company, or even the management of your company are not necessarily aware of even basic IP considerations. So how do you solve that issue? I would imagine that it would be better if some of the issues are captured early than late. So how do you solve that issue? Do you see a role for training? And how do you provide that training? What frequency, which topics, whom in the enterprise?
So of course, so from somebody coming from a big company, and you know the situation. So in the big companies, training is something very obvious, very normal. So when employees get into the company, they get all the kind of legal IP. If they are engineers, they get IP training. There is a huge departments where they can go and ask for support, and anytime there are external counsels providing training every time. So training is kind of the most obvious thing in big companies. In smaller companies, again, it's something that is not the first priority of the business, because at the end of the day, it's all the interest of the business to have the basic concept of IP distributed into their engineers. So we're developing a whole program of training, but not only to employees, because again, the engineers need to understand how to document what they are doing, how to differentiate background from foreground IP. That's for the day-to-day work. But what is also necessary is to educate all the management, all the sales people, how to offer IP solutions, IP-related solutions, how to include that into their offers, how to see the opportunities of adding IP to their offers, and also all to team up with all the finance people to understand how to monetize that and how to protect that with the insurance department. So it's a whole different levels of training. That it's more what I consider is the education of the company. Is kind of, and you only can do that if there is a conscious decision of the management of the company to embrace the IP game. Where I keep saying the game, because it's, for me it's a group of elements. It's a combination of elements. You cannot just have an IP lawyer. Isolated, because that will not be able to do anything. So you need to have a whole decision of the company to say, okay, we invest in IP at all the levels, because it's going to be another resource that we add to our assets.
That's great. I was, as I was hearing you, I thought, hey, it sounds like you're probably not the only company with this type of issue, and coming up with an IP training program should be something readily available on the market somehow. Do you get that from your law firms or IP firms? Do you think the suppliers of IP counsel are doing a good job with providing with this kind of tool, or is that maybe something that they should consider developing?
It's a gap in the market, maybe. Well, what I see, honestly, again, coming from an environment of very IP sophisticated, from a not so much sophisticated IP environment, is that whether you are in, whether you are out. So you have the support of law firms, IP professionals that are very much experts on a very specific niche. Whether it's patent, they are not even just expert in patent, they are in patent investigation, patent, it's really on a sector, it's very, very specific. And if you talk about copyright, again, there are huge difference between sectors. And it's difficult to find comprehensive business-oriented IP support. And what Nick, our colleague, were talking about before is kind of give that overall strategic advice to companies. Is something that, yeah, you may get like through trade associations that they are trying to promote the use of IP. But like from a business perspective, it's difficult, and I guess it's just because, like I said, it's a very holistic approach that involves lawyers, but involves also finance, and involves all kind of disciplines there.
So there is no YouTube video that you can go and tell your engineers, go see for 10 minutes and You will know the
maybe
10
it's an
things.
idea. Maybe it's an
Hey,
idea.
there is an opportunity there for, you know,
That's true.
show of hands, who is a supplier in the room? One?
Only one.
Well, you don't have a lot of competition, so it sounds like it's a good freemium model where, you know, you provide the YouTube video and you will generate a lot of follow-up activities based on that.
But I think it's also...
I have a client right here, so Loreto is distributing cards.
Yeah, but I think it's a handicap that the lawyers we have. It's we like to be experts in our niche, and we don't like to talk in general terms, because then we will get into the steps of somebody else, and we just want to be specific, and that's great. But that's a language that the business don't follow at all. And then the more that you want to be specific, the more that you lose people in the way.
Right, and I think it's very interesting. So I think in a way we are asking the business to move out of their comfort zone and understand the IP, but it feels like maybe we should do the other half, or even maybe more, and hopefully with the help of our talented suppliers, give the business something which is digestible for them. And so we talked about risks, and it sounds like a lot of the conversation is IP as a potential risk, as a blocker. We heard all the horrible issues that could happen with a risk of supplier materials, risk of dealing with customers who sues you because you reuse whatever you develop for them.
Injunctions?
Yeah, injunctions. Let me go through my notes. Export control issues, confidentiality breach, all sorts of good stuff. So what is how do you present IP more as an enabler? You know, is there such a way that you can maybe show IP in a more positive manner? What would be an approach for that?
So what I try to use is kind of the return on investment equation. So again, we have a lot of manpower. That's what we do in our company. But you can, at the end of the day, you can only do so much with your time and with the time of your engineers. So you need to be as efficient as possible, reusing your own resources. And for us, it doesn't mean to add another engineer. It means to use the work of engineer as most effectively possible. So for me, the IP, embracing the IP, is to say, okay, yeah, it's a complex world. It requires some investment, some long-term decisions, some budget. But you can make a business case on that and develop business based only on the IP. And that's something that for companies like Microsoft may be obvious, that of course you make money out of software. Of course, that's your business. But for companies like mine, to say, okay, you can make money just with the methodology or with the code that one of your engineers is putting together between jobs, like between having two assignments, that engineer that is a very expert on whatever technology could develop a software, a code that can be implemented for various business, not even in a project, but just kind of a standalone product. So even that concept, that is kind of the most obvious thing for a software company, is not obvious for other companies that are not used to do that as part of the product. So that's what I try to say, is like there is a whole world of opportunities there. It just requires the time to get into the game.
Right, so now you're talking about using IP to look at new business models for your company and new ways to structure the relationship with clients, so that they don't necessarily buy time and materials, as you said, but actually more IP assets. Mm-hmm. And then you have more clarity on what they get and what how you can reuse it. And it sounds like a much sounder business model with fewer risks.
Yeah, but it depends again, because we work, for example, with Airbus a lot. Some clients, they don't want to have external company creating anything for them. And again, that's an education of the customer as well. They just want to have engineers that follow their instructions. Whether they have an IP policy internally or not, that's another matter. But sometimes you, again, depending on the kind of product you are, our engineers could also help shaping the IP policy of the clients, because they are by definition more sophisticated than the engineers of the company, because that's what they are added to their staff. So it's not obvious what the clients ask for when they get our services. And if we are not able to even make that value proposition of, look, I can help you with even with your IP, developing your IP, then it's a lost opportunity.
Thank you. I would like to open the floor for questions now. I don't know if anyone has a question. Yes? I think there is a mic coming, so please be patient.
Hello, Loreto. Can you hear me well? Because I don't have a lot of voice. Okay. We know each other. I'm Maudrice Kozao-Frazzini, and I work for Qualcomm. First, thank you, because it was a very good presentation, and I really like, the way you shaped it. You mentioned IP. I would like to ask you, now in your job, what kind of IP? Is it more like patent? Is it more trademark? Are you able to do some trade secrets because you're always in front of customers? I would be very keen to hear more about that. Thank you.
Hello. So it's good that you mentioned trade secret, because we were thinking about mentioning that, and we just lost the track. So in general, in my company, we do have some patents, but that's by no means our core business, even if we are engineers. It's mostly about software. Trademark, of course, we have our logo and all that, and we also have some methodologies that is kind of certified by us at the quality standards that we have. But again, that's kind of a small area. So for us, the core business that we have is our the way our know-how, I would say. Depending on the industry, is how we approach methodologies, how we approach industry processes, and that's very difficult to identify as a specific IP. That's why the new directive on trade secrets is kind of, it's very good for our niche of business, because we are in that area that is very gray on, again, depending on the project, we may develop something, we may develop a study that can be copyrighted, we may develop a specific database on how to deal with the specific data or data analysis that we could protect. But again, it's case by case, and we don't have the resources internally to go in each project and identify if we could do something with that or not, and we are not at that level that our engineers could identify themselves. We may, if I give them in training, but we are not yet there. So the trade secret, I'm trying to develop that education internally on how could we use that protection that we have right now. And again, it's very difficult because it's a concept that is very new in Europe. Not all companies even understand. In some countries, it's kind of buried into other legislations. In some countries, there is no even notion of what is that. But for me, it's kind of a great concept to help us say, okay, there is a value in whatever we are giving, even if it's not an IP. And we want to protect that. And at the end of the day, all the confidentiality issues we follow already. That's something that in my company is kind of understood, because we are used to work for somebody else, and we understand all the needs to keep it secret and all the market value of giving information. So that's something that is already embedded in my company. But then is the next step is to use that in our benefits and say, okay, we just don't keep the confidentiality of the information from the customer, but also our information is valuable, is important, and we want to keep it like a trade secret, because that could give us value if we need to protect ourselves.
Thank you very much. Any other question?
I would like to make a question. if possible, for the audience. So I would like to have some, I know there are some practitioners, law firm practitioners in the audience. I would like to have some information about when they are approached by companies, what's the level of sophistication that they see? Because again, I don't even know if when they get approached for a new client, even for a patent application, if they see that difference on the level of awareness on IP, or how do they deal with that with their clients? Volunteer.
So we have one volunteer on my left, and then another one in the gentleman in the center.
I think the answer to your question depends very much on the sectors. Again, some sectors have no clue about IP. Some sectors know a lot about intellectual property. If you take the music industry, the organizations in the music industry, the publishers, the record companies, the organizations, the trade associations, they know more, in my experience, about intellectual property in their own sector than most lawyers do, because that's what they do day to day. And also, I think, in some parts of the fashion industry. But, in my experience, people in the technology industries are ignorant. They may know that they can get patent protection, but they tend to live, and I say this as a director of a computer software trade association, they live in their own little worlds. They don't mix with the real world, and they don't really understand what the rights are that can protect them other than just the fact that you can get a patent. But when you then say to them, well, you can get a patent, but you must make sure you haven't disclosed this invention to anyone else beforehand, that's news to them. And so really, I think you have to look at it sector by sector, and you can't generalize.
Just a quick follow-up. I have noted we have another, but do you see that maybe I think it's interesting to have a view by industry, as maybe the laws are similar. For instance, copyright laws would be similar in music as to software, but when you look at in practice and the actual side effects of certain provisions, they may be completely different. Also for patents, they are, we have same laws, but then when you talk at pharmaceutical companies or tech companies, again, the patenting practices are very different. So just I don't have any question actually. Next.
No, it's very hard to ask any questions if you already posed so many. No, I think there are some generalizations to be made. My observation is the younger and the smaller the company, the more ignorant. All large companies tend to have large legal departments, patent departments, and internal training programs. There is, I think, quite a difference per technology sector. And geographically as well. My observation is German companies, any Germans here, tend to be relatively well aware of IP. French companies tend to kind of ignore IP. R&D institutes in France, on the other hand, are very well aware of the existence and potential value of IP. And technology-wise, I would say mechanics less, electrical engineering, semiconductor, everybody is well aware of the huge portfolios and the risks. Software is not so much, I think, ignorance, it's an attitude. There's a strong feeling that open source should be open, and patents are by definition bad and evil. So those are the observations. I would think that there are some generalizations, but it's true. It depends on, in the end, the industry and the geographical origin.
Yeah, if I can add that, according to my experience, then if you have, for example, an R&D center which is close to the headquarters of the multinational company, then there will be a big IP awareness because the IP department is there and they're there to raise the awareness. But often in very remote R&D centers, that's not the case, and often it helps then to put a local person there to be aware of the IP and to generate the IP awareness, and that's often where we are asked for help.
Well, I also would like to add to that. I'm working as a legal and partly IP consultant in a really big R&D company, and the researchers, they just hate us because we're reluctant to just let them do their research. We're mingling with everything. We're saying you can't disclose this to this person and you cannot do that, and please, if you find something or you might have an invention, just come and seek us. So they would rather just sneak under the radar and ignore us. So I'm really happy I'm not aware of everything that is happening in the technical department, because from time to time something passes and then you have to solve the problem because some researcher has signed the copyright assignment form on his own, binding the company, and then you're like, oh my gosh. So sometimes I get a heart attack. Sometimes I'm less stressful when I just don't know. So my question to you was, your company has much more people involved, like 13,000. How do you create the compliance on the floor? Because with us, legal and IP is in a tower, all the rest is in clean rooms. How do you do that, so that they actually have the incentive to firstly come to you and ask advice, or follow up what was negotiated in the contracts with suppliers and all your other collaboration partners?
Yeah, I see your point, because I keep saying that the legal department, the sales make the joke that we are the sales prevention department, right? The legal department. So it's always trying to overcome that bias that the lawyers are there to make things difficult and to put yet another layer of approval, yet more procedures to follow, and it's difficult to change that into, look, I'm a business partner and I'm here to save you time and money in the long run. It's all about, and it's an education that needs to come from the top, and it's a long process because they need to see the benefits of involving you. So of course, if you are so busy trying to fight the fire, it's difficult to create anything proactive like education or training. But in the long run, it really pays off to explain why. And I'm doing legal training that is really a business training. It's why we the lawyers look into things. I will never ever mention regulation or a law specific, never. I always try to translate that into business vocabulary and say why lawyers look at limitation of liability, and then trying to explain, okay, look guys, there is a revenue recognition if you are committed to do that, and then you have to pay. You see, it's kind of the consequences, and it's some things that may be obvious for us. Is not the way they think about it, because they even don't understand a word about what is a limitation of liability. That something for us is okay, kind of obvious. So it's not about explaining the law, it's about explaining the consequences. And if you go there, and if you, for example, with the engineers, they are very proud of what they create. So I try to get and say, okay, guys, you don't want somebody taking advantage of what you have done. So again, it's trying to get into the reasons why is this important, the money that you could save, the issues that you could prevent. If it's all about compliance, well, yeah, it's IP infringement and documentation, all that, but it's a whole area of confidentiality and all kind of compliance that you need to educate them why it's that important. It's not an obligation in the sense of, okay, I have to add that to my day job. It needs to be part of the creation. But it requires a lot of education, not just of the engineers, but I think from the top. If the top understand it, they will pass it down. If not, it's kind of much more difficult.
Thank you. Any other question? Oh, yes?
Hi. Just to piggyback really quickly off of what Sigrid said and what you just mentioned, it's interesting that she mentioned, sort of getting a lot of grief from the research team because, and that you yourself as a lawyer sometimes have to deal with it, with people getting concerned about you, poking their nose in what they do. Usually when there's too much pushback, that's when we get called. So I'm with Black Duck Software. We're the open source guys. We do the open source scans on people's software. I'm the one who's been handing out the little black rubber duckies you've all been seeing. But it's interesting that you bring this up because half the time when we get called by a company or by an outside counsel or in-house counsel, a lot of the time they'll share with us that the problem that they're facing is internally within their organization. It'll be an in-house counsel, and they're very concerned about what risks they're facing, particularly with their open source. Usually it's compliance risk, license risk, and they'll come to us and say, I don't have a good way of getting a hold on this without, pissing off half the people that I work with. Can you guys come in and do a scan for us? And usually we'll come in and generate that report. But it's very interesting to hear you sort of describe that use case. So, and I think one way to combat that up front is, as you mentioned, just as much internal education as possible and really explain to them that you're trying to make their lives easier.
Yeah, and be part of the business. Because I just, in my company, I go to the sales people and I say, okay, guys, I want you to invite me to your business reviews. And they look at me and say, but we don't have any litigation. Okay, we don't have any legal matter. Okay, but I just want to listen about the business. I want to know who your customers are, who your competitors are, what the issues that you are facing in your day-to-day work, because that could really customize my advice to you. And with the engineers is the same thing. You need to understand at the minimum, what are they doing? You need to understand the issues that they are facing, the kind of technology that they work at. They need to see that when they talk to you, you understand what they are talking about, because then you are part of you are an advisor instead of a policeman to cut them. And then they may even come to you, I agree with you, they come to you with there is a problem that is too late, most probably. You can try to remedy or limit the damages, but then it's too late. And you need to somehow position yourself like a partner in the whole process, trying to get involved before the problems are there. And that requires a lot of time because then you need to learn also with them. They need to allow you to learn, and that's not always obvious that they allow you, the foreigner, to get into the discussion, their business, the technologies, and that requires also the time to get there. But I think it pays off in the long run because you really focus also. You can, what I try to avoid is to give a generic advice. When I'm asked like a lawyer, most of the time you get a request of, okay, I'm trying to do this and that. Is that legal? Wow, everybody here that works in-house knows how difficult it is to answer. Of course it's legal, but you may not want to do it because all this, all the rest around it. So it's no point to tell them what is in the law, if it's possible or not from a law perspective, because yeah, that may be perfectly legal, but maybe it's no sense whatsoever from a business perspective, for a strategy point of view, for a long-term policy. So you need to be able to understand all the rest to really have a value on your advice. And that's why I think it's more difficult when you are a lawyer in a law firm. It's much more difficult to really customize your answer than when you are in-house.
Thank you. Any other question? I think we are. Oh, another follow-up over here? Yeah, of course. You are standing between the crowd and the lunch.
I could keep asking questions, but
That's why I'm asking permission.
Yeah, I have no problem. Please.
Okay, so this is a bit of a sidetrack, but how is a company like yours, heavily involved with software and everything, dealing with the GDPR? Because yeah, it's a headache and it's a burden, and so it's a general directive for data protection. They unitized it for Europe, and the thing is, they will be stricter, and the difference is summarized. They can just audit your company to check and see whether you took enough measures to safeguard access and confidentiality of data. And everybody is afraid due to the high fines, and they don't have to announce anymore, just do the audits. So you have to be prepared. But yeah, how do you approach it, and are you really going to assess a data protection officer which is independent in your company or not? Because small companies, if they have an audit and they don't comply, they will go bankrupt. And those are the people who are most worried. Also startups and software and the like. So,
and not only you, but also your suppliers. You need to check that your suppliers are compliant, because if not, that could backfire on you. And you will start being asked by your clients if you are compliant. And they will say, I don't do business with you until you show me that you are compliant. So again, all those three aspects. It's not only the own obligation, it's kind of the ecosystem that will be created, that everybody will be trying to blame the other party for them to be compliant first, or trying to blame your lack of compliance on the lack of compliance of the others. So it's a big issue, and also again for companies that operate in different countries. My company is very much compliant into single countries, like in France, for example, we are compliant with the CNIL to the latest, and in Germany. So if you take individual countries, we do very well. But if we take like the whole group of companies, there is no policy, a combined policy. And that's one of the new regulation is asking for, that they will ask the whole group of companies what is the overall position on that. So we are doing that analysis of how to ensure that we have at least the minimum level at a group level, that the minimum requirements are covered, and it's again a matter that what I'm trying to do from the legal department, so I'm responsible for that, but I'm trying to pass that on to other owners as well, because it's kind of for the IP that I don't want to be perceived like a matter from the lawyers. And I think Nick was mentioning that before. It's kind of, we the lawyers, it's like the GDPR is exactly the same thing. So we, the lawyers, deal with that because we are the only ones who have read the regulation, if ever. But what I try to explain is that it's not an obligation of the legal department. It's an obligation of all areas, mostly HR that should be involved. Security, risk internally, audit, and IT. IT is a big partner into that, and that's what I'm trying to really be sure, because even if it takes longer time to educate employees and managers and procedure and departments to abide to a procedure, you need to be sure that with your IT guys that they understand what's going on, because you need to be sure that everything, even if it's not perfectly documented, that at least it's on the technical side, you can show that to start with. So I see a lot of similarities in that kind of educational process from a company that starts from zero, getting into a new world. And then, yeah, it's kind of education. The problem is that with IP, you may decide you get into that or not. But with the GDPR, you have no choice.
All right, thank you. I think we are at the hour. Just to food for thought, as you were describing this, I was wondering whether everybody was ready to handle the inventor personal information in a way which is GDPR compliant. So I leave you with that. And thank you very much. And thank you.